committee will be in order, and we recognize the chairman of the full committee with the understanding that Ms. O'Connor is on her way back, but recognize the chairman for his opening statement.
Thank you, Mr. Chairman. And I took special note of your hearing today. The series of hearings you've held really are critical to a full and complete understanding of the scope of the injustice going on before, during, and after the discovery of the IRS targeting of 501c4 groups. Today's panel is an excellent panel, and I look forward to hearing all of their testimony. I think the one thing that we all know is that solutions for large bureaucracies, and particularly ones that operate by necessity behind closed doors, must first start with a full admission of what has happened, what safeguards existed and were not observed, and what safeguards did not exist. This committee has discovered that the safeguards of confidential information are selective, and that, in fact, the safeguards to protect against the release of private information, although they failed at times at the IRS, are currently being used to hamper investigation and the public's right to know who was targeted and for how long, and in fact who is still being targeted. I know tomorrow you will have a list of groups, both nonprofit 501c3s and 501c4s, all of whom are opposed to the very selective partisan change that the President has proposed. I am more concerned today with this hearing because DOJ's decision, prosecutory discretion, appears to be a clear abuse of discretion. There is no doubt that DOJ claimed to be doing investigations, but the highest law enforcement officer at the FBI could not name someone. The Attorney General seemed not to know anyone, and there have been mixed statements about nothing was expected to come, but maybe it would come. This is as ambiguous as the Attorney General's statement that he will leave sometime in 2014 or he won't. I believe that our committee has, and with your leadership, Mr. Chairman, has an absolute responsibility to make sure that the Department of Justice reconsiders their investigations and their possible prosecutions of people who abused the trust of the American people. And so for that, I am already in your debt, Mr. Chairman. I look forward to this hearing, and I very much believe that this committee has a special role in making sure this never happens again. Thank you, and I yield back.
I thank the Chairman for his statement and for his leadership on this issue and many others. And with that, we will turn to our distinguished panel. Mr. Terwilliger, you're going to start. You got 5 minutes. And there'll be members trickling in and out here, but you've done this before, so fire away.
Thank you, Mr. Chairman. Mr. Cartwright, members of the committee, thank you for inviting me to express my views concerning the Justice Department's investigation of possible abuse of IRS authority. I am not here today to opine on the merits of the underlying allegations of improper conduct involving the IRS. Rather, I agreed to speak to what is, in my experience and best judgment, the appropriate means for the Department of Justice to conduct such an investigation. That background and experience at the Department of Justice began when I served while in law school as a law clerk in the civil appellate section and ended when I was the acting Attorney General at the conclusion of the Bush I administration. In the 15 years in between, I served as a career Assistant United States Attorney and as the Deputy Attorney General, as well as a presidential appointed United States Attorney. I also would like to note at the outset that so long as we have a tax system that depends on voluntary payment by our citizens, we need a strong IRS capable of performing tax examinations and enforcement that can render the tax system equal and fair for all. I'm sure most IRS personnel work hard to do just that. But if, from either within or without, their work has been despoiled by the actions of a few, then obviously that needs attention. Two fundamental points establish why questions need to be answered concerning how the matter is being addressed by the DOJ investigation. First, any credible allegation that IRS powers of inquiry or approval are being influenced by or used in furtherance of partisan political objectives is a matter of the utmost concern and needs to be investigated credibly and thoroughly. Second, and equally important in my view, public confidence in such an investigation is critical not just to this specific matter, but more broadly to the Justice Department's institutional responsibility to secure the independent administration of justice. These two very critical objectives affecting public confidence in government have now, due to a combination of circumstances, been put in jeopardy by legitimate questions concerning at least the appearance of independence of the current DOJ investigation. How can the public have confidence that an investigation under the control of the Attorney General and subordinates at the Department of Justice will be vigorous in its pursuit of the truth and fair in its analysis of the facts when the President has already stated, in effect, that there is nothing to it, as he has publicly stated while the investigation's been pending? Public reports also state that the prosecutor leading the investigation or substantially responsible for it has provided financial support to Democratic Party campaigns, including the President's. I do not believe such contributions should disqualify this lawyer, nor do I believe that the lawyer assigned is, on account of such political contributions, incapable of conducting a vigorous and thorough investigation. Nor do I believe as a general proposition that the decision as to whom to assign to a case for investigation or prosecution ought to turn on whether a given prosecutor has a particular political affiliation or association. However, given the circumstances as they have developed in this matter, if the objective is to assure the public that an investigation of allegations that government officials in this administration may have intentionally impeded the exercise of First Amendment rights by private citizens, then this is a case where more investigative independence rather than less is needed. I am no fan of the now expired independent counsel statute, and nothing I say today should be construed as suggesting that we put that law back on the books. It is not needed because the Attorney General already has wide authority to make investigative assignments to persons within or outside the Justice Department that can assure the public of the independence and integrity of an investigation. Such appointments are not new, and examples of them abound. Current FBI Director Comey, for example, while serving as acting Attorney General under President George W. Bush, made such appointments. So did Attorney General Reno during the Clinton administration. And while I served as Deputy Attorney General and Acting Attorney General, we made such appointments. In each of these and many other instances, the common factor in making such an appointment is taking steps to assure the public that an investigation of unquestioned integrity will be conducted. In my view, it is past time for the Attorney General to act in this instance, to use these authorities and appoint a lead counsel for the investigation of alleged IRS abuse who will have a charter of independence. Such an appointment is needed to provide assurance of the integrity of the investigation that the public deserves, and respect for venerable Justice Department practice is required. I thank you.
I thank the gentleman. Ms. O'Connor.
I thank the Chairman, Ranking Member, members of the committee. Thank you so much for inviting me. I speak on my own behalf as a private citizen and not on behalf of my firm or partners or clients. I hope to bring to you some of the understanding I have gained through my many decades of working with the Internal Revenue Code and therefore with the Internal Revenue Service, including the 6 years I was privileged to lead the honorable and dedicated men and women of the Justice Department's Tax Division. Americans deserve to trust and respect the institutions of their government. Revelations that the machinery of government might have been turned against our own citizens damage that trust, and I'm grateful for your efforts to learn the whole truth about the group of government activities that have collectively come to be called IRS targeting. Perhaps you're more limited than this in your current inquiry, but for my purposes, the targeting you should be considering is not just the disparate and apparently discriminatory treatment of certain groups in the processing of applications for tax exemption, but also the leaking of confidential information, the disproportionate selection of certain groups for examination, what appears to be a coordinated attack by a multitude of Federal agencies based on information that might be available only to the Internal Revenue Service. I hope that you're looking into the entire spectrum of what looks very much like serious misconduct by IRS and perhaps other government personnel. The U.S. tax system depends on Americans taking it upon themselves to gather their tax information and prepare and file their tax returns every year. One reason they're willing to do this, to provide personal information to the government, is the government's solemn promise, embodied in law providing criminal consequences for its violation, that the information they provide will be kept in the strictest confidence. When people form organizations and apply for tax-exempt status, they are entitled to expect that their confidential information will be respected as such, that their applications will be processed promptly and considered fairly, in accordance with the applicable law, not in accordance with special procedures designed just for them. On a Friday last May, a planted question at an ABA conference prompted an IRS official, just in time to get out ahead of an IG report, to admit that the IRS had, as some had long suspected, been targeting conservative groups for additional scrutiny. By Monday, according to news reports, Ways and Means Committee Chairman Camp, Senate Finance Committee Chairman Baucus, the President, Senate Majority Leader Reid, former Speaker Pelosi, Senator Warner of Virginia, all had expressed outrage and said something must be done. These were all a day before the IG's report was even issued. The day it was issued, news reports noted that the President's half-brother had received in just over a month determination of tax-exempt status for a questionable organization he had been operating for more than 2 years. Early the following week, a group of nearly 20 organizations spanning the political spectrum had expressed concern about this serious threat to the First Amendment. What a shame that members of the House and Senate squandered the opportunity then to immediately use the tools at their disposal to specially authorize an investigating committee, to appoint a special counsel, to engage an outside counsel to investigate them. I turn now to the administration's investigation of these matters. My written testimony outlines the federal regulations that describe the authorities of the civil rights, criminal, and tax divisions. Generally speaking, the tax division handles all litigation, civil and criminal, trial and appellate, arising under Title 26, the Internal Revenue Code. But when criminal offenses to be investigated and prosecuted involve allegations of misconduct by IRS personnel, the investigation and prosecution is the responsibility of the criminal division. The Civil Rights Division is charged with the enforcement of the nation's civil rights laws. DOJ officials have selected a career attorney in the Civil Rights Division to conduct the investigation. Some have criticized the selection as inappropriate because of her political contributions. But when does support for a sitting president and his party make a person an imprudent choice for an assignment? Not usually, but perhaps it does when the assignment is to investigate the administration's alleged mistreatment of its political adversaries. Here's why. Justice must not only be done, it must be seen to be done. This has two elements. First, when wrongdoing comes to light, the public deserves to know that those responsible have been identified and dealt with appropriately. Second, not only must laws be enforced impartially, but they must be seen to be enforced impartially. This is why judges recuse themselves from cases, not because they can't rule on them impartially, but because there might be something that would make the public think they're not impartial, and damaging the public trust is a dangerous thing to do. In 1959, Ian Fleming had his character Goldfinger say, "Once is happenstance, twice is coincidence, 3 times is enemy action." We know, because the Treasury IG's administration report says so, that groups banding together to promote an understanding of and fidelity to our nation's founding principles were targeted for special scrutiny that was harsh, intrusive, probably unnecessary, and resulted in a delay, if not the constructive denial of their applications for tax-exempt status, effectively silencing them during the better part of 2 election cycles. We know, because they had the courage to come forward and tell us about it, that people engaged in activities directed at improving the integrity of our elections were targeted for scrutiny not just by the IRS, but also by other arms of the federal government. We know, because we've seen it in the public domain, that the private information of people who contributed to organizations devoted to preserving traditional values was made public in violation of laws providing for fines and imprisonment of up to 5 years. As an American who cares about our country and our laws and our future, I thank the committee for continuing to press to learn the truth about what appears to be the administration's targeting of people who disagree with its policies, and encourage you to use all the tools available to you to do so. Thank you.
Thank you, Ms. O'Connor. Mr. Von Spakovsky.
Thank you, Mr. Chairman. I appreciate the invitation to be here today. I'm a career veteran of the Civil Rights Division of the Justice Department. I also spent 2 years as a commissioner at the Federal Election Commission, where we worked with the Public Integrity Section of the Criminal Division when there were potential civil and criminal violations of the Federal Election Campaign Act. Now, on May 14th of last year, Attorney General Eric Holder announced that he was opening up an investigation of the IRS targeting of conservative organizations, something that he called outrageous and unacceptable. Yet the Justice Department has refused to provide this committee with any information or updates on the investigation. Now, it's certainly true that the Justice Department cannot reveal sensitive information, but an active investigation does not prevent the FBI and the Justice Department from giving Congress basic information that does not compromise the investigation. There's no reason why the Justice Department can't provide this committee with a briefing on, for example, how many FBI agents and Justice Department lawyers have been assigned to the investigation, who the lead lawyer and supervising FBI agent are, what Federal statutes the lawyers are reviewing that they believe might have been violated, what the general plan is for the investigation of this matter, and without identifying them specifically, what types of witnesses they have already interviewed or intend to interview. The Justice Department and the FBI—
Mr. Vance, if I could just interject for a second, I apologize. But in your experience, were those kind of pieces of information given to congressional committees and to people inquiring about investigation? Were those done in the past?
We would give basic information, yes.
All the time?
Not specific information.
But I mean basic information you just outlined in your—
Yeah.
Okay. Thank you.
They could also provide you with how long they expect the investigation to take, what progress has been made to date, and when they expect to conduct their preliminary or final review. None of this information would compromise the integrity and confidentiality of the investigation. Yet lawyers representing dozens of the targeted conservative groups say their clients have not even been contacted or interviewed by the FBI. I find it simply incredible that 9 months after the investigation was opened, little or no basic interviews have been done with the victims about their dealings with the IRS employees who may have been involved in wrongdoing. In addition, there's the troubling selection of Barbara Bosserman, a lawyer in the criminal section of the Civil Rights Division, where I used to work, as the lead lawyer in the investigation. She's given almost $7,000 in political donations to President Barack Obama's presidential campaigns. Now, the criminal section where she works prosecutes cases, and this is according to their own website, quote, involving the violent interference with liberties and rights through the use of force, threats, or intimidation. Now, as bad as what the IRS may have done, I don't think anyone would characterize the actions of IRS employees as violent. I find it difficult to understand why the Public Integrity Section of the Criminal Division is not conducting this investigation in its entirety. This scandal involves possible corruption, public corruption, by IRS employees. It is the Public Integrity Section of the Criminal Division, not the Civil Rights Division, that has long been responsible for investigating and prosecuting this type of public corruption. That's made clear on its own webpage. And General Holder would certainly know that. Why? Because the very first job he got out of law school when he went to the Department of Justice was in the Public Integrity Section of the Criminal Division. Now, DOJ claims, and others have said, that Ms. Bosserman can't be removed because it would be, according to Justice, a prohibited personnel practice to consider political affiliation making personnel decisions. That claim totally mischaracterizes the situation. Taking a lawyer off a particular case because of a conflict of interest or the possible appearance of a conflict of interest is not a prohibited personnel practice. A prohibited personnel practice would be if they terminated her, changed her pay, disciplined her because of her political views or her political donations. No one questions the fact that Federal employees can give political donations, but the rules that govern the Justice Department specifically say that lawyers are supposed to avoid even the appearance of corruption and anything that would cause the public to question the integrity of an investigation. Now, that certainly is the case where we have an investigation that potentially could embarrass the administration being conducted by a lawyer who has given a large amount of money to the President, and we have a situation where the President has already told her and others in the Justice Department how he wants their investigation to come out, because he says there's not a smidgen of corruption involved. Taking a lawyer off a case at the Justice Department to avoid a conflict of interest is a routine occurrence at the Justice Department. DOJ should be making every effort to conduct a thorough investigation and avoid any questions about the objectivity of the attorneys and investigators involved in the investigation. The possible bias of one of the supervising, if not lead lawyers in this investigation, is a very serious issue. When combined with the refusal of DOJ to provide even basic information about the status of the investigation, as well as the seemingly unjustifiable delays in talking to key witnesses, substantial questions are raised about whether or not a serious and unbiased investigation is being truly conducted. Thanks.
Thank you. Mr. Ivey, you're up for 5 minutes.
Thank you, Mr. Chairman. Members of the subcommittee, I appreciate the opportunity to testify before you today. My name is Glenn Ivey. I'm a partner at the Washington law firm of Leftwich and Ludaway, where I specialize in civil and criminal litigation. I'm a former Federal prosecutor, an elected State prosecutor, and an adjunct professor of law. I'm very familiar with these types of issues you are considering here today in the oversight hearing. By way of introduction, I spent about half of my career as a prosecutor. I served as an assistant U.S. attorney in Washington, D.C. from 1990 to 94, first under U.S. Attorney Jay Stevens, and then for 2 years under U.S. Attorney Eric Holder. Before leaving, I handled about 45 criminal jury trials and argued appeals and conducted grand jury investigations. In 2002, I was elected State's Attorney for Prince George's County, Maryland, a jurisdiction of about 850,000 people that covers the eastern border of Washington, D.C. During my 2 terms there, we handled a variety of high-profile investigations that sometimes overlapped with the U.S. Department of Justice. I also became a founding chairman of the Association of Prosecuting Attorneys. Finally, for the past 17 years, I've taught courses on advanced criminal procedure, white-collar crime, and others at the University of Maryland School of Law. With respect to the length of the investigation, I understand from my review of statements by subcommittee members and hearing testimony that there's concern about the length of this investigation. While I was State's Attorney, my office conducted several investigations, in fact many, that took long periods of time to complete. Sometimes I was accused of taking longer than I should, but as my father used to say, you measure twice and cut once. It's critical for prosecutors to be extremely careful and thorough in conducting their investigation, because they might not get a second chance to do it right. Certainly when it comes to a matter as sensitive as this one, there should be no rush to judgment and no pressure to cut corners. It's more important to do it right than to do it fast. Moreover, I also had the experience of waiting for the Department of Justice to complete investigations my office had referred to the Department. In one case, an accused cop killer was found dead in his prison cell just 2 days before he was arrested for the murder. In another, a college student was beaten by local police officers when a college celebration spun out of control. In these and other cases, my office sometimes waited months or even years before the Federal investigation was completed. So I understand that there can be frustration in waiting for the results of Department of Justice investigations, especially in high-profile matters that have captured a good deal of public attention. Sometimes long investigations lead to public questions about how the prosecutors are conducting the investigation or whether it could have been completed more quickly. Nevertheless, I think it's critical to give prosecutors the time they need to conduct a careful and thorough investigation, particularly in matters with this degree of sensitivity. With respect to confidentiality, I know from personal experience that there can be a great deal of pressure on prosecutors to release information while an investigation is ongoing, but it's important for prosecutors to control the flow of information made public during the course of their investigations for several reasons. First, prematurely disclosed information can undermine an investigation by tipping off potential witnesses about the scope, direction, and details of the investigation. Second, individuals who might be named in the course of an investigation but ultimately cleared of wrongdoing, should be shielded from the negative impact of disclosing incorrect information about them. Finally, any information that is gathered pursuant to the laws that require secrecy, like Rule 6E, might require a court order to be released. That reflects the longstanding view held by both Congress and the courts that matters before a grand jury should largely remain secret before trial. In the short run, these secrecy rules may conflict with the goal of transparency and disclosure. Elected officials want updates, the public and the media want real-time information, but in the long run, it usually makes more sense to allow the criminal investigation to run its course before public disclosures are made that it might undermine or even preclude a criminal prosecution. With respect to the politics issue, a hallmark of the Justice Department is that it allows its line prosecutors to do their jobs without forcing them to disclose their political views or bend to political considerations. That's why the Department has career prosecutors who have sometimes spent decades in office, despite the changes in presidents and attorneys general. This provides consistency in the handling of cases, helps to retain top talent, and preserves institutional memory. It also helps to reassure the public that regardless of who is at the top, the line prosecutors will wield their power and handle their cases based solely on the merits. I know the committee has received letters from the professors that the ranking member mentioned a moment ago, so I won't speak to that, but I do want to say that with respect to my personal experience, I saw these principles in action while I worked at the Department. Fortunately, during the transition that I was present for from the Bush administration to the Clinton administration, line prosecutors were insulated from the politics of the day and allowed to conduct their work in an apolitical environment. After my election, I brought that approach to my State office. I worked hard to reduce the politics that swirled around the office, where line prosecutors had been expected, essentially as a condition of employment, to donate to their bosses' campaigns and to work for their reelection as well. Eventually, my line prosecutors came to understand that they did not have to contribute to my campaign and that I was not going to check whether they worked on political campaigns or made political contributions. My line prosecutors learned that they did not have to sacrifice their constitutional rights to work for me and that they could handle their cases based solely on the merits. That's the way it ought to be, even in high-profile matters like this. So thank you again for giving me a chance to testify today. I look forward to questions.
Thank you, Mr. Ivey. We appreciate you being here. Mr. Painter, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I teach corporate law and securities law, lawyers' ethics, and government ethics at the University of Minnesota. For 2.5 years, I was the chief White House ethics lawyer under President Bush. For the vast majority of Americans, the burden of federal and state and local taxes is excessive, and the regulations under which taxes are collected are excessively complex. Taxpayers are entitled to competence and impartiality from the government agencies that collect our taxes. It is unacceptable for the Internal Revenue Service to use politicized search terms to single out individuals and organizations for additional scrutiny. Whether such actions result from gross incompetence or from political motivation of IRS employees, it is serious misconduct. This misconduct took place in one of the most powerful agencies in the executive branch. The President must accept responsibility for it and make sure that it never happens again. Now let me discuss for a moment the 501c4 organizations and the issues related to campaign finance. These organizations are growing in number, and they have proliferated since the Supreme Court's decision in the Citizens United case. I discussed them extensively in my own book on government ethics that was actually written before that case was decided. I share the concerns of many Americans who are disgusted with the current state of affairs in campaign finance, and I believe that the future of our Republican form of government depends on finding some way for ordinary Americans, the vast majority of us who cannot afford to set up our own 501c4 or fund it, to have a meaningful voice in our government. There are many options, including enactment of constitutionally acceptable campaign finance reform legislation, enhanced disclosure obligations, and additional taxpayer funding of political campaigns. Close IRS scrutiny of 501c4 applications to discern so-called political purpose of an organization, however, is not the way to arrive at a better system of campaign finance. The notion that social welfare is somehow distinguishable from politics is, in my view, unworkable, particularly in a society where politics is the process by which we choose our government and social welfare is to a great extent helped or hindered, I believe usually hindered, by government taxation, expenditure, and regulations. Now, the IRS needs to focus on its mission, which is collecting taxes from people who owe taxes. And if the statutes and regulations invite the IRS to inquire into the political opinions or political purpose of persons or organizations in determining an organization's tax status, those regulations and statutes need to be changed. Now, more specifically with respect to the IRS, American taxpayers are entitled to an IRS which responds promptly to their requests, and delay in the response to a 501c4 application for any reason is unacceptable. And I believe Congress should impose on the IRS specific deadlines for taking action with respect to applications for particular taxpayer matters. And if they can't meet their deadlines, perhaps they should be paying us penalty and interest like we have to pay them when we can't meet our deadlines. As for the DOJ investigation, the Department has opened an investigation, but I believe that it has been compromised by the controversy over the staffing of the investigation. No particular ethics rule explicitly prohibits a career prosecutor who has made campaign contributions from participating in or even directing an investigation such as this one. Not knowing the present scope of the DOJ investigation or where it might lead, however, I cannot be certain that such a conflict would not arise. Now, I discussed in my written testimony the impartiality rule at 5 CFR 2635-502 that I believe should have led to a discussion within the Department of Justice about the staffing of this investigation. If I had been a senior official in the Department of Justice, I would have chosen in this instance to choose someone to lead the investigation who did not have strong affiliation with either of the two major political parties. Finally, I want to point out that there are serious Hatch Act issues here if, and I emphasize if because I do not know the facts in this matter, if IRS employees were politically motivated in the conduct that occurred. If there was an attempt here to influence an election, these 501c4 organizations do have an enormous impact on the outcome of elections. We all know that. And if IRS employees were politically motivated in these decisions, there are serious Hatch Act concerns, and I believe the Office of Special Counsel should be involved in this, whether they conduct their own investigation or whether they review the Inspector General's investigations and determine that no further action is required. But they cannot, in my view, responsibly remain silent. Thank you, Mr. Chairman.
Thank you, Mr. Payne. I want to thank all our witnesses for their testimony. We'll go now to the Vice Chairman of the committee, Mr. DeSantis.
Well, thanks a lot, Mr. Chairman. Thank you, witnesses, for your testimony. I think there's a little confusion here with what I'm hearing from the other side in terms of, yeah, you can give to a political candidate and be perfectly fair and do your job, and the idea that that should disqualify you, I don't think is what anyone up here on this side is saying. But I think what I'm saying and what I think some of my colleagues are saying is this is not like you're just investigating corruption at the Department of HUD for someone lining their pockets. You're talking about a misuse of one of the most potent agencies we have in this government to target dissent from the administration in power seeking to be returned to office in 2012. So that really strikes at the heart of what the First Amendment's all about, what limited government is meant to ensure, and I think the American people need to have the utmost confidence in the investigation. And so what do we know right now? Well, we know that Jay Sekulow came in front of this committee a couple weeks ago, and he has 40 clients who've been targeted by the IRS in one form or another. Not one of them, as of a couple weeks ago, had been interviewed by anyone associated with this investigation. What do we also know? We know the President went on national TV and said there's not a smidgen of corruption involved with any IRS targeting. It's amazing how he would know that, but nevertheless, that's what he said. And of course, we haven't gotten even rudimentary cooperation from the Department of Justice and the Department of FBI. So it may not be against the regulations to have Barbara Bosserman. Look, she's a loyal Obama supporter, and there's nothing wrong with that.
and it may not be prescribed exactly. Maybe someone make the argument it is. Just because it's not doesn't mean it's the right thing to do. And so I would say in this situation, given the sensitivities involved, why would you not steer clear of any appearance of impropriety, particularly given what we've seen over the last several months? I think turning to all these other career people in the Department of Justice would have made probably a lot more sense, who maybe just don't have any bone in this either way, but to go with, when you give $7,000 to the Democratic Party and President Obama, you're a loyal foot soldier in the Army of Hope and Change. I mean, let's just be clear about what we're talking about here. So I think, and so from my perspective, what I see now is I think we need a special prosecutor to look into this, just to avoid any of this, because guys like me, guys like the chairman, if this keeps going on and it just ends with a whimper, we're not going to have a lot of confidence in what happened. And I know the people who've testified in this committee, they are not going to have any confidence if that what ends up being the outcome. And also, how are you supposed to react when your boss, the President, says there's no corruption? I mean, what kind of signal does that send to these folks? So I think what we need is some independence here. So let me just go down. Mr. Terwilliger, do you think that a special prosecutor would be in order given these facts? I do. Okay. Ms. O'Connor? I do. Mr. von Spakovsky? I do. Mr. Ivey?
I guess I have mixed views about it.
Well, let me ask you this, because so you still elected, or you had served 2 terms?
No, I'm in private practice.
Okay. So, I mean, and you probably had people who were prosecutors who would be handling cases. You weren't micromanaging everything. People were probably doing their job. And it's a little bit different for you because you were a politician, whereas when the bureaucracy, you're not supposed to. But, I mean, if you would have come out and said, oh, well, there's nothing doing here, there's no corruption there, then probably your line prosecutors aren't going to then think that that's a good signal for them to go and pursue that matter. I mean, don't you think there was a little bit of a problem for the President to say that there's not a smidgen of corruption, given that we're supposedly in the middle of this investigation?
You know, I actually had a similar kind of scenario with the case I mentioned in my testimony, in which the police officer who had been killed, the guy who killed him was allegedly found dead in his prison cell. The county executive at the time announced that this was a lynching, and I had other elected officials who made similar kinds of statements, including some statements from police officials who, as you can imagine, grieving about the loss of a comrade, had strong feelings about it.
But in that instance, you're independently elected from the county executive, correct? So in other words, you didn't report to the county executive like someone in the Justice Department. Ultimately, in the Federal Constitution, you have one person in the executive branch that's elected, and everyone ultimately the buck stops with the President. So I take that point, and I do, and I think that is a good point. But I think the difference that I would just draw is ultimately you had an independent duty to your voters. You were not somebody who was dependent on any of those elected officials. Is that correct?
That's correct, although I'll say this. The police who actually reported directly to the county executive and many of my prosecutors who had just finished working for him still had strong allegiances. But with respect to the point about the Federal level of independence issue, unlike the independent counsel statute that Mr. Terwilliger mentioned, you'd still have a prosecutor, even a special prosecutor appointed by the Attorney General, and still subject to the same kind of chain of command, essentially, that's raising concerns here.
No, absolutely.
So the only reason I kind of hesitate about it is because the special prosecutor statute and regs looks a lot like, sort of setting it up, and I don't know that it gives you the type of screen that your concerns address. So I'm not saying it's not appropriate here, but I don't know that it really gets to the heart of the problem that you outlined.
Let me be clear, Mr. Chairman, if I may, just quickly. When I said I do to the Vice Chairman's question, I was addressing not an appointment under the independent counsel regulation, but the use of the Attorney General's plenary authority to appoint a special counsel to whom all the powers of the Attorney General could be delegated if the Attorney General believed that was the right thing to do.
Unbiased special prosecutor in light of the circumstances, in light of the fact pattern, unbiased special prosecutor makes sense in this case. Yes, yes, yes. And Mr. Ivey, you're a maybe?
Maybe, yeah.
Mr. Painter, could you answer?
If there's evidence of criminal activity.
Make sure your mic's on, please.
If there's evidence of criminal activity, significant evidence of criminal activity, the Justice Department should conduct an investigation. And in this type of situation, I think the investigation should be led either by a career prosecutor who is not affiliated with either political party or by an independent prosecutor. If there's no evidence of criminal activity right now, what I would do is let the Inspector General finish their job and the Office of Special Counsel, and then DOJ pick up from there.
Thanks, Mr. Chairman. Yield back.
Thank the gentleman. Mr. Cartwright.
Thank you, Mr. Chairman. Well, we've had a wide-ranging discussion, and I appreciate the presence of all of the witnesses here today. I always like to say here in Congress, people don't realize we agree on a lot more than what we disagree about. And I want to talk about what we can agree on. You know, the Chairman and I had a colloquy right before we went to go vote about whether it would be illegal, whether it would be against the rules for a person who gave a political donation, such as Ms. Bosserman. And I believe the Chairman was quite forceful in saying it would be illegal. Am I correct in that?
No, I simply read the rule, which said if there's an appearance of the appearance to the public that they might be biased, then that person should not be heading the investigation. I read the rule.
Okay. So what I want to do is I want to make sure we're all on the same page. Are any of the witnesses here today able to confirm or deny that Barbara Bosserman is leading this investigation? Just go ahead and raise your hand if you can say yes or no. Seeing no hands, I see that no light is shed on this question here. In fact, Attorney General Holder has testified that Ms. Bosserman is in fact not leading the investigation.
The gentleman yield for a second?
Certainly.
Do you know something we don't know? Do you know who is leading the investigation? Because we've asked. What we do know is Mr. Sekulow testified under oath in front of this committee that the highest-ranking official he has interacted with and the limited interaction he's had, the highest-ranking official at Justice Department who's interacted with him is Barbara Bosserman.
And reclaiming my time, as is absolutely crystal clear from all of this discussion, we do not have evidence that Barbara Bosserman is leading this investigation or any other, and all we're doing is stabbing around in the dark and making suppositions here and there, which I suggest respectfully to everyone involved is an inappropriate use of our time and energy, making suppositions like that. I also want to follow up on the question of asking line prosecutors about their political donations. We have a number of people here who have worked for the Justice Department, people who know about this, and I'll start with you, Mr. Terwilliger. When you were at the DOJ, did you ever check the political donations of line prosecutors before assigning them cases? Yes or no?
No, but I certainly would consider removing.
I only have limited time. Ms. O'Connor, did you ever check into the past political donations of line prosecutors before assigning them cases?
I did not, but I did have a trial attorney who was criticized by a conservative columnist on the basis that he believed he was a Democrat attacking Republicans.
Make use of my time. Mr. Ivey, what about you? Did you ever check prosecutors' past political donations when you were the state's attorney for Prince George's County?
No.
No, and in fact, quite the opposite. You made it very plain to them that you didn't care about their political donations. You wanted them to operate in a politics-free environment, didn't you?
Absolutely.
All right. In fact, doing so, asking about past political donations, I think Professor Painter has brought up, would raise some serious legal and ethical concerns under the Hatch Act, as well as under civil service laws. Professor Painter, is it appropriate for DOJ officials to look up career prosecutors' political donations in order to identify potential conflicts of interest before assigning cases?
No, I wouldn't do that.
Let me follow up. Mr. Professor Painter, what are some of the problems with DOJ or any other prosecuting agency searching the past political donations of career employees such as line prosecutors?
Once you get into that, you get into a situation where you could create the appearance of retaliation against someone because they donated to a political campaign, usually a campaign that opposed the President. That is not where you want to go, and that's why the applicable ethics code that I referred to puts the onus on the employee to identify those situations where they think there could be a question about impartiality.
Thank
you. It's the employee's job.
Thank you, Professor Painter. And I suppose I should call you Professor Ivey as well. Did you also teach trial advocacy at Harvard?
I do, yes.
So you're in the Ivy League. Do you have anything to add to the discussion?
With respect to this issue, I do think that one concern should be the potential of a chilling effect. So I get the point about Ms. Bosserman, and there's thoughts that, maybe if you had it to do over again, you wouldn't put her in place. But now that she's there, if you remove her, you really do send a message to all the other prosecutors out there that if you've given contributions, you better stop. And if you've been thinking about doing it, you better stop, because you might not be able to be assigned to these types of cases.
Dangerous precedent. Thank you, Mr. Ivey. Appreciate it.
Mr. Twiller, I just want to give you a chance to respond fully. You were going to say more. While you indicated it's not appropriate to examine political contributions prior to assigning cases, once you have discovered the facts, once you know she's a max-out contributor to the President of the United States, who may be a potential target of the investigation, would it then be appropriate to look at saying, hey, she should be removed after the fact, after you learn that fact? I agree with my colleague. You can't be looking that information up ahead of time. But once you know, particularly a case of this sensitive nature, where your most fundamental First Amendment political rights, your right to speak out in a political nature, is what was the issue at hand, then is it appropriate to say she should be removed from the case?
Of course it is. And this isn't a...
And not just from her, but from people, her superiors as well.
Absolutely.
And did you do that at your time at the Justice Department?
Of course. I mean, I'll use an example to take it out of the political realm. I wouldn't bar a lawyer from being hired at the Justice Department because in that lawyer's career, he or she may have represented mafioso in the past. But I wouldn't necessarily put them in charge of a large organized crime case either. And it's the same, even if they were initially.
Or if they got assigned a large mafia case and you found out after the fact in their past they had represented people there, would you remove them?
Of course.
Of course.
And the reason you would do that, and the reason it's not only proper and not only an exercise of good judgment, but is required because there's a duty to avoid even the appearance of impropriety, a duty that's been recognized by the Attorney General himself in recusing himself from other matters. It's been recognized by Preet Bharara, the United States Attorney in New York, who's a highly reputable and accomplished attorney who has removed himself from cases. I removed myself from cases for that reason. And if the circumstances require, in order to assure the public of the integrity of the investigative process, no matter what kind of case it is, a superior has an obligation.
So the way this should really have worked is Ms. Bosserman just said, you know what, Mr. Attorney General, or you know what, Mr. Tom Perez, who headed the Civil Rights Division when she was assigned this case, you know what, I may have a conflict. We need to talk about this. They talk about it and he says, oh, for goodness sakes, you certainly do. We're going to have let someone else head this investigation.
That's what one would hope would happen.
Mr. O'Connor, would you agree with that analysis we just went through with Mr. Terwilliger?
Will the gentleman yield for one
Sure.
question?
I'm going to let Ms. O'Connor answer because you didn't give her a chance, and I'll come to you.
I agree completely.
Okay. Mr. Cartwright?
Okay. Again, one of the reasons I'm here is to try to help protect the integrity of this outfit, the House Government and Oversight and Government Reform Committee. And to protect the integrity of this committee, I say again, we should stop referring to Barbara Bosserman as the lead investigator on this investigation. We have no evidence of that.
Does the gentleman from Pennsylvania know who the lead investigator is?
I'll read the testimony from
No. I asked a specific question. Do you know who it is?
It is the Criminal Division of the Public Integrity Section that has actually got the lead, quote unquote, from the Attorney General of the United States.
Do you know who the individual is?
I do not.
Yeah, but we could have...
Not Barbara Bosserman.
We could have maybe known this.
I ask that we stop referring to her as the lead if we want to preserve our own integrity.
Jay Sekulow, under oath, confirmed she's the highest-ranking official at the Justice Department who he's interacted with. That would lead us to believe, again, we had a chance. We invited Barbara Bosserman to come here and testify, and you said, you sent me a letter saying, don't subpoena her. We gave the opportunity to the number 2 at the Justice Department to answer my question 3 weeks ago, who's heading the investigation? He wouldn't answer me. So all we know is what we've heard from